Good morning. This is Albert Chang, Chair of the New Mexico Oil Conservation Commission. It is just after 9 o'clock on July 27th of 2026, and so I call the meeting to order. This is a special meeting of the State of New Mexico's Oil Conservation Commission, and we are meeting today to primarily for case number 25875, application of the Oil Conservation Division to adopt various new rules under the NMAC. If I could have a motion to approve the agenda. Oh, I'm sorry, I apologize. Let's start. Could we start with a roll call?
Yes, Commissioner Ampoma.
Present.
Commission Chair Chang.
Present.
And Commissioner Paige Chosky.
Present.
Great. Now I think I'm ready to entertain a motion to approve the agenda.
Mr. Chair, I did review the agenda, and I so move that the agenda be accepted.
May I have a second?
Second.
Any objections?
No objections?
Hearing no objections from commissioners, so adopted. On today's agenda, I don't have any minutes to approve or any other mechanics, right? Okay. In that case, I will call case number 25875, and I will turn it over to our hearing officer who has been appointed for the matter, Ms. Orth. Thank you.
Thank you, Mr. Chair. Good morning. My name is Felicia Orth, hearing officer appointed by the Commission to conduct the hearing in the matter of the application of the Oil Conservation Division to adopt Rules 19.15.41, 19.15.42, and 19.15.43 of the New Mexico Administrative Code, docketed by the Commission Administrator as case number 25875. We have a few things to do this morning. The rulemaking will be conducted under the Commission's rulemaking rules. Testimony will be taken under oath and is subject to cross-examination. For our Commissioner Chosky's benefit, for joining us this morning in the rulemaking. Questions are posed first by all the other parties and then by the Commission and/or Commission Counsel on the way to a decision. No decision will be made this week or this month. We believe we'll continue through this week and at least part of next week. Before ending, I will invite public comment each day that the hearing proceeds. Today, I'll invite public comment at 4 p.m. and every subsequent day that we are actually in hearing, I'll invite public comment at 9 in the morning. If you would be offering public comment and would desire simultaneous interpretation between English and Spanish or Spanish and English, there will be interpreters available during the public comment session of August 4th and again on August 7th if in fact we again make it to August 7th. There's a post-hearing process which the parties will have an opportunity to make their closing arguments and offer up findings of fact and conclusions of law, or draft statement of reasons really for the Commission's decision. And everyone will be informed as to which meeting the Commission will be deliberating on the petition. So we have a number of parties here. Let's begin with appearances. Mr. Tremaine.
Good morning, Madam Hearing Officer, Commissioner Chang, Commissioners. Welcome and thank you for being here today. This is Jesse Tremaine for the applicant Oil Conservation Division.
Thank you. And do we have Mr. Pavlik or Mr. Cox? Perhaps online?
Yes, good. Yes, correct. Good morning. This is Zach Pavlik. I represent the Center for Biological Diversity, and my co-counsel, Colin Cox, is also online at the top.
Thank you, Mr. Pavlik. And for the conservation groups, Ms. O'Grady.
Good morning, Madam Officer and Chair Chang, members of the Commission. My name is Morgan O'Grady. For Dene Care Earthworks, San Juan Citizens Alliance, Sierra Club Rio Grande Chapter, Tonajone, and the Western Environmental Law Center. With me at Council's table is Attorney Rose Rushing. Thank you.
Thank you. Welcome. For OCC, let's see, I think it's Mr. Tucker.
Good morning, hearing officer and commissioners. Aaron Tucker of Holland and Hart on behalf of OCC USA. Thank you.
Thank you. For NAMOGA, let's see.
Good morning, hearing officer and commissioners. Ana Gutierrez with Womble Bond Dickinson. We also have Jessica Portness online on behalf of New Mexico Oil and Gas Association. Thank you.
Thank you very much. And WildEarth Guardians.
Good morning, Madam Hearing Officer, Mr. Chair, members of the Commission, Samantha Ruscavage Bars for WildEarth Guardians.
Thank you very much. All right, just a few other pre-hearing matters. We did have a motion to postpone and dismiss for lack of authority under the relevant statutes. I had indicated to council verbally and apologized for not having prepared a written recommendation before now that I would be recommending to the commission that the motion be denied. I think perhaps what might be best this morning so that we have it on the transcript is just a brief kind of summation of your argument. Would that be okay? No more than 10 minutes?
Madam Hearing Officer, I may defer to Zach Pavlik if he is prepared to take this on.
Yes. Mr. Pavlik, can you argue there from the platform? Just summarize the basis for your motion to dismiss, if you would.
Yes, I can. Just one moment, Madam Hearing Officer, please.
All right. And then, of course, I will go to Mr. Tremaine and any other counsel who'd like to weigh in.
I'm sorry, just pulling up my notes here. Okay, thank you. Okay, yes, thank you for the opportunity to argue this, Madam Hearing Officer, and just briefly summarize our position. This motion was brought by the Center for Biological Diversity, Dene Care Earthworks, San Juan Citizens Alliance, Sierra Club Rio Grande Chapter, Tonajone, and Western Environmental Law Center, along with WildEarth Guardians. This is a joint motion to dismiss for lack of jurisdiction for this rulemaking. In summary, what the motion argues is that neither the Oil Conservation Commission nor the Oil Conservation Division have the authority under the relevant statutes to proceed with this rulemaking and to ultimately adopt any rule under this rulemaking. In terms of these arguments, the two statutes that are relied upon by the Oil Conservation Division, the applicant in this matter, to suggest authority, those are the New Mexico Oil and Gas Act and the Carbon Dioxide Stewardship Act, the Geologic Carbon Dioxide Storage Stewardship Act. I'll refer to that as just the Stewardship Act. In terms of the, I guess, beginning with the New Mexico Oil and Gas Act, we believe that that act does not supply the requisite authority for this rulemaking because the long-term permanent storage of CO2 is a separate class of wells, and it is a separate program from the traditional New Mexico Oil and Gas Act regulated activities that the Oil Conservation Division undertakes. So the New Mexico Oil and Gas Act concerns the conservation of oil and gas. It also grants authority under a few narrow other subsections of activities that OCD performs, and those are specifically articulated in that act. They have to do with things like waste, produced water. However, the Oil and Gas Act does not provide authority for an entire new program and new class of wells, including the extensive permitting and regulatory framework that OCD has put forth in this rulemaking. In terms of the Stewardship Act, that act is, of course, specifically tailored to the long-term storage of CO2 underground. However, that Stewardship Act is also very clear in its grants of authority. In terms of its authority granted to the New Mexico Oil Conservation Division, it grants authority for largely post-operation ongoing stewardship. That involves, according to the Act, it involves receiving certificates of closure. It involves confirming that all of the closure requirements have been undertaken by the operator, as well as then sort of negotiating and navigating the terms of the state's ultimate takeover responsibility for those Class 6 wells. However, it does not allow for the expansive framework that is put forth in this rulemaking, in these proposed rules. So the Stewardship Act does not touch upon all of the permitting, all of the technical requirements, all of the site characterization, all of these other aspects of the rule that OCD has currently put forth in the draft. Additionally, and I think maybe more importantly, in terms of the Oil Conservation Commission's authority under the Stewardship Act really only grants a very express and narrow authority to establish a fee structure for the stewardship fund that is created by that act. That stewardship fund is meant to help fund OCD's activities with regard to post-closure. Importantly, the Oil and Gas Act grants both of these regulatory bodies, the Oil Conservation Commission and Oil Conservation Division, concurrent authority, which would then allow either of those entities to undertake activities for which the other entity has authority to undertake. That's not the case in the Stewardship Act. In the Stewardship Act, each entity is named individually, and there is no express grant of concurrent authority. And I think it's probably good for our purposes. In terms of just the summary of the reasons, it really just comes down to having the authority for the rule as currently put forth by the applicant. And it's our position that without the concurrent authority that is present in the Oil and Gas Act, and without authority under the Oil and Gas Act, the Stewardship Act does not go far enough to allow the Commission or the Division to promulgate this rule. Thank you.
Thank you very much, Mr. Pavlik. Mr. Tremaine, will you summarize your response, please?
Yes, Madam Hearing Officer, thank you. I will not. I will rely on the papers to get into the detail, but I think I can summarize with a few key points here in regards to the motion to dismiss. The division's position is that we do in part rely upon the Oil and Gas Act to provide the structure for permitting, enforcement, inspections, and investigation generally. That's the existing structure upon the framework upon which all of the activities of the Oil Conservation Division have been built. However, in terms of the Geologic Carbon Dioxide Storage Stewardship Act, which for the rest of the hearing I will simply refer to as the Stewardship Act, to save us some time, there's really two key provisions, like right at the beginning of the act, and I think that we could spend some time arguing different legal interpretation, et cetera, but here is really a plain language argument that in 74-14-3A, the act sets forth that the Stewardship Act applies to sequestration facilities that commence injection of carbon dioxide after the date of the act. Okay, and then 74-14-3B expressly provides authority to the Oil Conservation Division to do two things. We have all necessary authority to enforce the provisions of the Stewardship Act, and the division is authorized to adopt and promulgate rules and issue orders for the implementation of the provisions of the Stewardship Act. And that is all the further I think this argument needs to go. The division is acting upon the express authority under 74-14-3B and has submitted this application to promulgate a rule in seeking the grant of UIC Class 6 primacy from the EPA. Because CO2 sequestration facilities are the exact same type of facility that are contemplated in Class 6 regulation that are currently permitted or allowed to be permitted in New Mexico by the EPA. So what we are doing here is trying to promulgate rules that bring regulation of those facilities closer to New Mexicans, that allow us to promulgate regulations which take into direct consideration the specific needs of the geology, the environment, and the people of New Mexico. And the way in which we promulgate those rules is to bring an application before the commission. I think in terms of the statutory construction argument, distinguishing the rule promulgation authority between the division and the commission is fruitless, and we have that express authority, so that is how this process is how we promulgate those rules. Thank you.
Thank you, Mr. Tremaine. Is there any other counsel who'd like to be heard on this question? No? All right. So, commissioners, my recommendation is to deny the motion to dismiss, given the broad authority extended by the New Mexico legislature to this commission and the division under the Geologic Carbon Dioxide Stewardship Act, which we should all just call the Stewardship Act at this point, the New Mexico Oil and Gas Act, and the Safe Drinking Water Act, which authority was actually included in the Stewardship Act. I think the totality of that authority actually does authorize this commission to adopt the petition for these three rules, because not only is there express authority, as Mr. Tremaine has set out, there is also authority that is fairly implied from what is set out expressly under New Mexico case law. If you have questions, I'm happy to answer them.
Commissioner Mpoma, any questions?
Yeah, Mr. Chair, if I may, I do have a question both for the applicant and then also for OCD, if I may. Mm-hmm. Okay. So I'm looking at the Stewardship Act rule, the law that was passed, and I'm looking at Section 3, subsection B, and I'll read that. So the division has the jurisdiction and authority necessary to enforce the provisions of the Geologic Carbon Sequestration, Carbon Dioxide Sequestration Storage Stewardship Act, and may adapt and promulgate rules and issue orders for the implementation of the provisions of that act. So my question to the applicant is, explain to the commission how OCD is going to be able to implement the Stewardship Act, where you do have EPA having the primacy over UIC Class 6 projects. But OCD can still go in there and then implement the Stewardship Act. Is there a correlation there? How do you more or less align these two?
I just.
To the applicant first.
The movement, I'm sorry.
Yeah, the movement.
To the movement.
That's what I wanted.
Oh, okay. Sorry about that.
Oops, sorry. Can you? I don't think I completely understood the question. You're wondering how to align the authority that the applicant or that OCD has currently to implement parts of the Class 6 sequestration program?
Let me try to summarize it. So what I'm asking you is, EPA do have the primacy, New Mexico do not have the primacy over Class 6 projects, right? Now, this rule is asking OCD to implement Stewardship Act. So I'm asking you, and I read the provision in there that gives OCD the authority to promulgate rules and issue orders for the implementation of the act. So I'm asking you, how do you square where OCD doesn't have, or let's say New Mexico do not have primacy over Class 6 projects, but you are saying that this rulemaking is not really, they are not really following the rule here. So how do you square, the Stewardship Act where OCD will more or less issue or more or less implement, and then they do not have primacy?
Thank you, Commissioner Mpoma. Yeah, I understand now. So our position is that currently they do not have primacy. They are not able to, in this case, regulate Class 6 wells. And the Stewardship Act does not give them the authority to do so in the broad fashion that they seek to do so. So there could be an instance, for example, in which a state takes control of regulating a certain subpart of a program. And there are ways for both the EPA and a state to regulate certain parts of a program under this sort of a structure. So our position is that the Stewardship Act does give OCD in this example, which we see as separate from OCC, but does give OCD authority to regulate and to promulgate rules in order to fulfill the purposes of the Stewardship Act. But based on its language, the Stewardship Act is not as broad as this rule. The Stewardship Act specifically relates to post-injection activities, post-injection stewardship, and other post-injection, post-operational aspects of the Class 6 program. So OCD does have jurisdiction and authority over those activities as granted by the legislature. But any rule that it would seek to promulgate would have to be within the bounds of that authority, which does not extend to complete regulation of the Class 6 program. That would remain with the EPA.
Will OCD respond?
Yes, was there?
Yes, if I may, Commissioner Mpoma, may I add a little bit to Mr. Pavlik's response? Two additional points to make. Before a state can obtain primacy from the EPA, it has to show the EPA that it has the statutory authority to regulate the program that it is trying to take on. So I think it's really the first question before even looking to primacy is, does the state have the authority to take on this program? And this is a little bit relevant, but also in response to what was discussed earlier. Traditionally, the Oil Conservation Division asks the Commission to pass and promulgate rules. That's the customary way that it passes rules. However, typically it is passing rules under the Oil and Gas Act, which explicitly provides authority for the Commission to pass rules. And so saying that it is the common practice for the Commission to pass rules on behalf of the division, who here has authority to pass some rules, I think we can all agree, under the Stewardship Act, that doesn't actually help the commission here in showing that it has statutory authority, because there is no, unless you're relying on the Oil and Gas Act, if you're only relying on the Stewardship Act and the provision that you pointed to, Commissioner Ampoma, the commission doesn't have explicit authority to pass rules on behalf of the division under the Stewardship Act. Thank you.
Thank you, Madam Hearing Officer. Jesse Tremaine for OCD. So first off, I want to start with I think the last thing that Mr. Pavlik said about post-injection activities. The Stewardship Act, that first section, 74-14-13A, the act applies to sequestration facilities. If you look at the definition of sequestration facility, which is 74-14-2F, there's an expansive list of activities that fall into that definition, or equipment and monitoring equipment, et cetera. So carbon dioxide injection wells, monitoring wells, devices, science wells, external monitors, et cetera, that are all pre-injection and during injection. So the act does not cut off at post-injection activities. Sections of the act do speak to post-injection, post-closure, stewardship transfer, et cetera. But the act as a whole stands for the proposition that the division has been vested with the authority to regulate the entire program. In response to Commissioner Ampoma's question about how the OCD could implement this program if we don't already have primacy, first, I would point out that the state of New Mexico has concurrent authority with other agencies and the federal government on any number of topics. For instance, the New Mexico already has primacy for all other UIC classes, 1 through 5. Class 2 sits with the Oil Conservation Division, as you're well aware, covering saltwater disposal injection wells and in certain cases, acid gas injection wells. The EPA still has authority there as well, but the state is acting in primacy first and foremost, but the EPA could, if necessary, assert that authority and regulate over those wells. So this would not be an uncommon structure. Secondly, and I think the best answer here is that really what you're asking is an order of operations question, which is that so OCD has the authority to regulate sequestration facilities and under the Stewardship Act. And in order to effectively implement that program, we have to promulgate a rule. All right, so one of the requirements, as Ms. O'Grady just indicated, was that we have to, after this hearing, go back to the EPA. We've been discussing this project with for the last year and a half, 2 years, and demonstrate to them that we have the statutory authority that's already been discussed and that's already in the works with the EPA. And then we have to show them the rule so that the EPA can vet that the rule that New Mexico has promulgated is at least as stringent as their rule. Right? They will not grant primacy to New Mexico for us to take over that program unless we can say it's at least as protective in any particular way. That requires a very large amount of work, comparison, and drafting between the rules, and this will explain, and I'll go into some more detail later about why the rules are structured the way they are, why we've relied so heavily on the EPA language and the structure of the rules, why this is 3 parts instead of 1 part. Et cetera. All of those are considerations that were intentional, whether they look it or not, because we've adopted the EPA structure. So we have to have a rule. Now, if you promulgate a rule and then the EPA says, no, you don't get primacy, the program won't stand up, practically speaking. But we have to do this before we can get to primacy.
Does that answer your question, Commissioner Ampoma? Mr. Chair?
Well, I'll defer to our new commissioner.
No questions.
Okay. So if I could follow up with a question, Ms. O'Grady. So I want to separate and think about this in 2 different ways. One's the process, which I think you alluded to about the division of labor between the commission and the division, and the way the statute was written, granting rulemaking responsibilities and authorities to the division, but doesn't specifically call out the commission. And then we can separately talk about the scope of that particular act and what kinds of rules, whether or not the commission is the right forum, separate from the scope of what the OCD is asking for and whether that fits under the act. So let me turn to the process question first, because I get where you're going. I mean, I see your argument that the statute explicitly uses the word division and doesn't use the word commission in the relevant operative provisions here. Is it possible, in your view at least, that that's because the legislature saw the two acts as operating in concert and therefore granting the OCC, or by granting rulemaking authority to the division, they understand that the Oil and Gas Act, which already existed at the time the Stewardship Act was passed, would have the process run through the commission? Because I'm trying to figure out is, what would that look like, right? If the legislature intended for rulemaking to happen outside of the commission via the division, I'm trying to figure out whether that's an interpretation, whether taking such a narrow view of the literal wording of the statute of the Stewardship Act could hollow out the purpose of the Stewardship Act, because we would end up interpreting the words of the legislature as asking an entity that does not have a rulemaking function, or that doesn't have a rulemaking process to conduct rulemaking, right? Like, wouldn't that be inherently in tension with itself?
Thank you for the question, Chair Chang. I do understand your point, and I can't speak to what that process would look like for the division to pass rules, because it is my understanding that typically they ask the commission to pass rules. However, these are housed in different parts of the statutory framework, right? The Oil and Gas Act is in, and forgive me, Chapter 72, and this statute is housed in Chapter 74, which I think is very curious because there's nothing else for the Oil Conservation Division within Chapter 74, to my knowledge. I think that if this were housed within Chapter 72, absolutely you could tie back to that provision granting concurrent rulemaking authority to the division and the commission. But unfortunately, because it's housed in Chapter 74, it seems like, to me, like a strained reading of the statute to say they intended to tie back to a very different statute.
Fair enough, and I appreciate that. But on the flip side of that, and I'll let OCD weigh in too, the flip side of that is then we've got a legislative directive to make rules to a body that can't make, and correct me if I'm wrong, but it seems like that would be interpreting the legislature's statute in a way that is inherently contradictory the way it's drafted.
I don't have a great response to that, Commissioner Chair Chang, and perhaps other council have other responses. I think it may have been an oversight of the legislature and a mistake, perhaps, or yes, perhaps. I don't know exactly what they intended. I don't know what that process would look like for the division, but I don't believe the division can look to a different chapter for authority for the commission to pass these rules.
And certainly, on behalf of the commission, I always hesitate to even imply that the legislatures would have done anything that was less than perfect drafting. OCD, would you like to respond?
I would. Thank you, Chair. I apologize. I meant to answer this in the last question and didn't write my note. I think that to clarify the roles of the division and the commission, I think the legislature spoke to this years ago, and in 70-2, and to clarify for the record, it's chapter 70, Article 2, and that gets on the record, gets turned into 72 all the time. It's 70-2. So 70-2-6 B says that, well, A speaks to the division authorities, and B says that the commission shall have concurrent jurisdiction and authority with the division to the extent necessary for the commission to perform its duties as required by law. And then goes on. This would not, in 74 environmental improvement, this statute I would submit is located in Article 70, Chapter 74, because it relates to protection of groundwater, that relates to the Safe Drinking Water Act, et cetera. It is not uncommon for the Oil Conservation Division and Commission to issue orders, promulgate regulations, enforcement related to protection of ground or surface water. In fact, like groundwater discharge permits, for instance, the source authority for that does not come from the Oil and Gas Act. It's regulated by the Oil Conservation Division because the division has the subject matter experience and technical expertise to deal with the types of wells and facilities that are contemplated under certain specific sections of the Act. That is a more complicated example because that authority for Water Quality Act is split up between NMED and OCD. But we have this analogous structure throughout New Mexico statutes, and I think it is clear that was intended here. Also, just in terms of the statutory construction, the legislature is certainly aware of the language in 70-2-6, and I think that we have to give them the benefit of the doubt that they were aware of their own statute at the time that they promulgated the Stewardship Act, and that this was understood that the division was going to do this. In fact, it was, I would submit that there was a question of what agency should promulgate these rules, and it was specifically decided that this should be the Oil Conservation Division, and that's why this went into the Act, the specific language that's referenced there.
I have a question, Mr. Tremaine. My memory is that the preliminary steps for pursuing a rulemaking before any of the boards and commissions that make rules for the various agencies, especially the environmental agencies, is that a letter is required to go to the Legislative Counsel Service and the Small Business Association. Did that happen in this case?
It is my understanding that happened through the commission clerk, and we have received approval through State Record Center to promulgate these rules in these particular sections.
All right, thank you. Other commissioner questions?
Not so much a question, but I think I'm ready to make a comment. I think and make some recommendations to my fellow commissioners. I want to recognize, and I hear the movements reading, and I get it, and I thank them for a very close reading of the statutes here, and certainly appreciate the careful consideration of the scope of the commission's jurisdictions, and I certainly acknowledge that the last thing I want is to make everybody sit through 2 weeks of hearings only to end up out in some sort of outside the authority of the commission to act. But I want to turn back to the language in the Oil and Gas Act, which is 70-2-6B, where it says, I think, and OCD Counsel Tremaine just quoted the language here that says, the commission shall have concurrent jurisdiction and authority with the division to the extent necessary for the commission to perform its duties as required by law. It's not limited to this particular law or this act, and it simply says that the commission and the division has concurrent jurisdiction and authority as required by law in general. And so it is my view and my recommendation to commissioners that at least in terms of the process of whether or not the commission has the authority to participate in this rulemaking, it would be because we have the concurrent jurisdiction to perform a duty as required by the Stewardship Act, which is law, even if it's not part of the New Mexico Oil and Gas Act. And with that, I'll turn it over and see if there's further discussion on this point from other commissioners.
Mr. Chair, I do agree with your submission on this matter. So I believe even I am more leaning towards the recommendation from the hearing officer. Thank you.
And that said, I think we've addressed the process question of whether the commission has the authority to hear it at this moment, at least. But that does leave the question of scope of what exactly the rule entails and whether or not any part of a proposed rule that we get to at the end of the hearing may or may not be within the scope of what the statutes themselves confer. So I think I'm happy to take the recommendations from Commission Counsel and from Commission Hearing Officer at this moment. But if there does remain a question as to whether or not the rule at the end of the actual substance, whether the scope issues falls within the statutory grant, I'll speak just for myself at the moment, but I wouldn't be opposed to if parties still have a question about that at the end of the hearing when we have a better sense of what the scope of the rule looks like. I'd be happy to entertain, assuming my other commissioners agree with me at that point. But I think we can talk about whether or not the scope of whatever the package of proposed rules fit within the statutes at that point. But I think it might be a little early for us to weigh in on that at this point, since we haven't fully explored or given parties a chance to lay out what exactly the proposed scope of these rules are. Should we, at this point, should we entertain a motion, or how do you have a recommendation?
I would ask Mr. Chandler if you need a motion.
Madam Hearing Officer, Mr. Chair, a motion may be appropriate. I don't know what the motion is, so I don't know, but it's a possibility.
Well, I will let my other fellow commissioners weigh in at the moment, but I believe the motion would be to deny the motion to dismiss.
And Mr. Chair, so that will be whether the commission do have the authority to hear the case or not. That will be the first part. But you still leaving room if, let's say, other parties believe that the scope of the rule is more or less beyond the scope of the act, then they are still open to really address that.
My suggestion is to deny the current motion in front of us, to deny the motion. But I'm because who knows whether maybe the parties will all agree that there's no scope question at the end, right? But if there are questions, I think there will be a better time for us to address that at the end. But right now, I think my suggestion would be to deny the motion in front of us and proceed to the rulemaking. And if parties wish to renew a motion regarding the jurisdictional questions, we can take that on at the appropriate time at the end as a new motion.
I agree with Commissioner Chang to look at the scope as we go through the rule, because there might be some concerns of things that are missing. Sure.
Mr. Chair, with that, I so move that the application be denied at this time. The motion be denied at this time.
May I have a second?
Second.
Any objections from commissioners?
No objection?
No objections.
Without objection, so ordered. Thank you very much. I will turn the proceedings back over to our hearing officer.
Thank you, Chair Chang. So just to briefly summarize what we're facing here as we go forward, the next thing that happens is I will invite opening statements. Parties have the opportunity to make an opening statement this morning or to reserve their opening statement until they make their own presentation. Those opening statements are limited to 15 minutes apiece. Then we will hear from the Oil Conservation Division witnesses first. They have a total of 6 witnesses. 5 of them have both direct and rebuttal testimony. 1 of them has direct. The division has discretion to present their witnesses as part of a panel or individually. That's entirely up to them. We'll then proceed to, direct testimony is limited to 60 minutes, rebuttal is limited to 30, and then the other parties may cross-examine for up to 30 for each witness. We'll then hear from the Center for Biological Diversity, then the conservation groups, then OCC USA, and then each of which has witnesses. NMOGA does not have witnesses, but they are a party for purposes of cross-examination and argument. The same with WildEarth Guardians. And again, when we get to 4 o'clock, regardless of where we are in the technical case, I'll invite public comment, both in the room and on the platform. So, Mr. Tremaine, would you like to offer an opening statement? Oh, I'm very sorry. Hold on. Commissioner Mpoma has a question.
Yeah, quick one. So on the procedure here, I do have a quick question with regards to the cross-examination. Now, if you look at the applicant witnesses, I mean, there is one witness that is the chief witness. So I'm wondering if that 30 minutes cross-examination for all the parties is more or less enough. Because some of the witnesses probably will be 15 minutes, will be 10 minutes. But the chief expert, I'm not sure if 30 minutes, then it will be on me, yeah.
I would like to respond, Commissioner Mpoma. So one, I think that it is typical that we have witnesses whose duration of their testimony and their cross-exam is longer than others. And that is, some people in terms of questions do heavier lifting, but this is a true multidisciplinary group. And I think you're probably referring to Dr. Schnaar, the depth of the testimony and the direct testimony. But I would point out a couple things. One, these are the rules that all the parties agreed to. Two, we are, and I'll talk about the breakup, but we want to make sure that the right witness gets the right question. And so we're proposing to submit our witnesses in 2 panels. Hopefully you agree with the logic of how I've broken that up when we get there. And then each of the parties gets half an hour. So I think that's ample. And I have instructed my witnesses on the fact that the commission does not have time limits on its questions. So these are the rules of the venue. So we haven't constrained that at all. I do think that across the board, I think half an hour is fair, and in the interest of administrative efficiency, we've seen this in prior cases as well, that there has to be a cutoff in terms of cross-exam time, or if we started asking all of the witnesses about every paper that they ever wrote or commented upon, we could be here into September.
All right, let's see. So, Mr. Tremaine, would you like to begin your opening statement?
I will, thank you. Madam Hearing Officer, Mr. Chair, Commissioners, members of the public, and the other parties, thank you so much for being here and for all of the time, attention, and the extensive preparation that I know that the Commissioners and the parties have put into this case to be here today. We're here because the state has declared the attainment of Class 6 primacy, the only remaining UIC class for which New Mexico does not have primacy. This program has been a over 2-year priority for the state of New Mexico. As we discussed earlier, this is also met with legislative support in promulgation of the Stewardship Act, which enabled the Oil Conservation Division to regulate sequestration facilities in addition to its general authorities under the Oil and Gas Act. Carbon sequestration is a permanent carbon sequestration to be distinguished from temporary or enhanced oil recovery, CO2 injection, is a program that, if appropriately regulated, may present both environmental and economic benefits. New Mexico primacy for Class 6 would allow for the greatest local New Mexico oversight over projects and implementation of more stringent requirements than currently exist at the federal level. We got here because the OCD engaged a multidisciplinary team to assist with both the development, the public engagement, and the promulgation of the related rules. So you'll see that we have a lot of witnesses that are not OCD staff. We have relied upon New Mexico Institute of Mining and Technology as the chief contractor and subcontractors associated with I'll probably refer to New Mexico Tech generally throughout the hearing. And so those are 5 of our 6 witnesses are either associated with the university or subcontractors working for the university, specifically on this program. Our strategy broadly is to rely upon the existing EPA framework, both the regulations that are promulgated in the Code of Federal Regulations and their guidance, but to build extensively upon that for any areas where New Mexico proposes to be more stringent. In order to achieve primacy, the state must act on the authority in the Stewardship Act and promulgate Class 6 rules that are at least as stringent as the federal rules. If the commission promulgates these rules or a variation of these rules as a result of this hearing, this next step after that will be that the OCD will submit a final primacy application to the EPA, including the final rules as a part of that application. Again, most of the rules, I'm belaboring this point because most of the rules text will mirror the CFR. So deviations contemplated from the CFR, from that language, necessarily require review by the EPA and a stringency analysis. So we've been intentional about where we're proposing to deviate. Our intent, our presentation, OCD's response to public comments and the proposed red lines is to avoid edits that are not substantively necessary. This has also led to a process of the amended application and the proposed changes to the amended application reflected in OCD Exhibits 1, 2, and 3. As the final proposal submitted by the division, I will rely chiefly in reference on OCD Exhibits 1, 2, and 3. If those, as the final version, those were submitted as entirely new language, if there are questions regarding exactly how specific instances of those changes from the amended petition, I'm happy to share red lines on that. We have those prepared, but the proposed changes are the final proposal. Why did we make those changes? As those who have participated in recent rulemakings know, there are points in time, typically after a rulemaking, where formatting, citation styles, et cetera, are caught. I've seen this happen in recent cases. So I want to reiterate that we have not proposed substantive changes here based on lessons learned in prior rules and specific instances which Dr. Schnaar and others can testify to. There are reasons why, upon review for publication of the rule, that we identified additional changes were needed. And so specifically, our citation style and the federal citation style, they're quite different. And so this is a dense technical rule that has a ton of cross-references in it. So there are frequent changes to the final proposed rule because of those citation styles. The other one that is becoming a recurring theme in rulemakings is the and/or discussion, and that the scope of that issue when I submitted the amended application, it did not, frankly, catch the full scope of the issue. The underlying issue is that the Code of Federal Regulations actually uses and/or in numerous places. We did not realize early on in this process that that was prohibited under the legislative drafting manual in New Mexico. Did not catch that, so we have made that change. So it looks like there are a lot of changes, but they are, we can outline and speak about those individually, and those are the reasons for those. We are trying to do this up front so that those changes are not necessary or contemplated in the middle of the hearing or after a rule is promulgated. In terms of our order of presentation, our intent is to lead off with the direct and rebuttal testimony of Dr. Gregory Schnaar, and then move on to the Environmental Bureau Chief, Justin Wrinkle, and then Dr. Sai Wong. We'll follow him with Matt Eels, and then Dr. Hassan Kaniani, and then last we'll have the direct testimony of Jennifer Rainey. So in an effort to improve both efficiency and ensure that questions are directed to the right, to the appropriate witness, we would offer the division witnesses in 2 panels for cross-examination. So we'll go all the way through the direct and rebuttal testimony of each 6 of the 6 witnesses, and then I would propose, if it pleases the commission, 2 separate panels. The first one for cross and commission questions would be Dr. Wong and Dr. Kaniani. I think that they have very technical, very more specific testimony. And I believe that the questions will most likely be, logically sorted for those witnesses. The second panel would be Dr. Schnaar, Matt Eels, Jennifer Rainey, and Justin Wrinkle. And so that would cover the structure, that would cover any questions about the decision-making process, specific areas of stringency, et cetera. And just as we've discussed, I just want to express OCD's understanding that the other parties may present their witnesses for cross as they see fit and however satisfies the commission. We do not expect panel cross-examination of other witnesses. So in summary, in pursuing this promulgation of this rule for carbon sequestration, the OCD relies on the Stewardship Act, the express authority there, the Oil and Gas Act to provide the structure, permitting, and enforcement, inspection and investigation authority, and again rely heavily on that rule structure from the EPA, including the EPA guidance. And I think that will become clear as we work through and reference both the exhibits and rebuttal exhibits. So the intent of the OCD is to present this rule so that the meaningful discussion at this hearing is focused on the areas where New Mexico or the other parties propose to strengthen the federal regulations, and not necessarily the base language of those federal regulations. But ultimately, we believe that New Mexico now proposes a rule which will result in a grant of primacy for Class 6 to the state of New Mexico, and will protect the interest of New Mexicans through robust permitting, monitoring, and public participation. Thank you.
Okay, thank you. Let's see, Mr. Pavlik, would you like to offer an opening statement now or reserve?
We would like to reserve. Thank you.
Thank you. Ms. O'Grady?
Conservation groups would also like to reserve. Thank you.
Thank you. Oxy?
Oxy will be reserving its opening statement.
All right. Namoka? Ms. Gutierrez may have stepped away. WildEarth Guardians?
Madam Chair, WildEarth Guardians would like to go now.
Terrific. Thank you.
Thank you. Madam Hearing Officer, Mr. Chair, members of the board, Samantha Ruscavage Bars for WildEarth Guardians. Thank you for the opportunity to present this opening statement regarding the Oil Conservation Division's proposed rules. WildEarth Guardians is here today to raise a specific concern related to OCD's capacity to manage and enforce the requirements of the proposed Class 6 regulatory scheme if it's enacted. Because our concerns are essentially issues related to OCD's budget and staffing for the Class 6 program, we will not be offering technical witnesses, so I appreciate the opportunity to offer this statement and to explain our concerns with the department's proposal. With respect to the motion to dismiss, just as an initial matter, WildEarth Guardians preserves all objections raised in the motion and also preserves any objections related to the Commission's decision to deny the motion. As OCD states in its petition for rulemaking, it's seeking to assume primary responsibility for permitting, compliance, and enforcement of Class 6 wells to fast-track the permitting of these wells, reducing the permitting time from EPA's 3 to 6 years to 6 to 8 months for approval at the state level. The reason OCD gives in its petition for needing to fast-track the Class 6 permitting process is, quote, bringing the state closer to achieving its waste mitigation and climate goals, unquote. OCD's petition also states a need to, quote, enhance both regulatory efficiency and environmental stewardship, unquote. Yet nowhere in OCD's materials submitted for this hearing does the division explain the specific waste mitigation and climate goals that the proposed regulatory scheme is intended to achieve, or how having primacy over the Class 6 permitting process will achieve these undefined goals or enhance environmental stewardship. Which begs the question of how a faster approval process for a relatively new and permanent industrial waste disposal method in the state actually benefits people, the environment, or the climate, when weighed against the catastrophic impacts to people and the environment when these injection wells fail and release CO2, as they have in other states. As the pre-filed testimony illustrates, failure of CO2 injection wells has led to asphyxiation deaths and long-term groundwater contamination. And injection-induced seismicity has resulted in earthquakes which caused personal injuries and property damage in other states. What is referenced consistently at OCD's pre-filed testimony is the need for speed in processing and approving Class 6 permits, with little evidence demonstrating that OCD has the staffing and funding capacity to ensure that its permanent underground waste disposal program will protect groundwater, communities, and future generations from long-term contamination risks. It's important to flag at the outset the complicated and highly technical nature of a Class 6 permitting program, as reflected in the proposed regulatory scheme and discussed throughout the pre-filed testimony of the parties. A Class 6 permit evaluation requires, at a minimum, structural interpretation, geomechanical analysis, pressure and fracture evaluation, reservoir simulation, predicted plume footprint analysis, and assessing the adequacy of the area of review and post-injection monitoring plan. Once the OCD goes through this process and issues a permit, it must ensure that operators comply with permit requirements, must track and review monitoring and other data, and manage emergencies when these injection wells fail. According to OCD's pre-filed testimony of Mr. Justin Wrinkle, the division is in the process of staffing the Class 6 regulatory program. Mr. Wrinkle states that when the Class 6 program is fully staffed, it will have a team of 3 employees for, quote, Class 6 permitting, technical review, compliance oversight, and long-term monitoring, unquote. He also states that the division will rely on geologists, engineers, field inspectors, and specialized technical contractors for technical expertise to support the Class 6 program. But it's unclear from the testimony whether these professionals are already on OCD staff, are positions that will be added in the future, or will be contracted to support the workload of the person's 3-person staff. The testimony does not include a discussion of workload allocation between permit approvals and oversight and enforcement, any information relating to the number of Class 6 permit applications OCD expects annually, or whether the small in-house team is an adequate staff to ensure both rigorous permit review and comprehensive post-permit oversight and enforcement. In addition to concerns about staffing levels for the Class 6 program, particularly the capacity for oversight and enforcement once permits are issued, WildEarth Guardians also has serious concerns with the tentative nature of the funding for the Class 6 program beyond the few full-time program staff contemplated. Mr. Winkle states that the 3 permanent positions are funded by the state's general fund. Funding for contract services required to support the full-time staff will come from, quote, a combination of existing funds and grant awards when such resources are accessible, unquote. Given the department's expected reliance on specialized technical contractors to review permit applications and to perform field inspections to ensure compliance with construction and operational requirements and ensure the safety of those operations, the funding caveat of when such resources are accessible is extremely troubling, particularly given the lack of any funding contingency plans in the pre-filed testimony. Given that OCD's purpose in seeking primacy is to fast-track Class 6 permitting approvals, WildEarth Guardians is concerned that any funding shortfalls in the program will result in program staff time being limited to permit approvals, with oversight and enforcement being relegated to an indeterminate back burner until some future point when OCD is able to obtain additional funding to hire more permanent or contract staff for those activities. If OCD is unable to ensure secure and sustained funding for all phases of an industrial waste storage program spanning multiple decades, then the Commission should not let OCD start something that it can't finish, especially when that finish here is ensuring decades-long containment of a poisonous substance. In closing, no matter how thorough a regulatory scheme is on paper, the words don't do the work. People do the work. And not just people to do permitting, review, and approval. OCD also needs people to ensure long-term permit oversight and enforcement. And people cost money, especially people with the requisite technical expertise needed to assess upscaling in New Mexico of a relatively new technology with a proven track record of failure in other states. The glaring omissions in OCD's pre-filed testimony related to these capacity issues should give the Commission pause in approving OCD's approval for Class 6 primacy, especially given the significant and serious stakes if even one of these waste storage wells fails. For these reasons, WildEarth Guardians urges the Commission to deny the proposed rules. Thank you for the opportunity to share our concerns.
Thank you, Ms. Rescavage-Bart. I think rather than interrupt your witnesses 10 minutes in, we'll take our morning break now. You can set up your witnesses. Let's come back at 10:25. We had an email communication from Namoga's council that they were unable to unmute themselves and reserve their opening statement. So, Mr. Tremaine, if you would, please.
Thank you, Madam Hearing Officer. I would proceed by calling to the stand Dr. Gregory Schnaar.
Mr. Schnaar, would you spell your first and last name, please?
Gregory. My last name is SCH, N as in Nancy, AAR.
Do you swear or affirm to tell the truth?
Yes.
Thank you, Dr. Schnaar.
Good morning, Dr. Schnaar. Could you please tell the commission where you currently work and what your job title is?
I'm a principal hydrogeologist with Daniel B. Stevens and Associates.
And are you currently working as a subcontractor with New Mexico Institute of Mining and Technology to support the rulemaking before the commission today?
Yes.
Okay. And are you testifying on behalf of the Oil Conservation Division as a technical witness today?
Yes.
Okay. Madam Clerk, if I may have share capability. Dr. Schnaar, to proceed, I'd like to ask you about a number of these exhibits as a threshold matter before we get into your direct testimony.
You should have sharing permissions.
I do not have sharing permission yet. So, Dr. Schnaar, are you familiar with OCD exhibits 1, 2, and 3, the proposed changes to the amended petition?
Yes.
Okay. And I'm wanting to share screen with you, but I think with your familiarity, I'll just try to get some foundation for these. And you have reviewed the final versions of those exhibits?
Yes.
Are they true and accurate to the best of your knowledge?
Yes.
Okay. And is it true that exhibits 1, 2, and 3 represent the division's final proposed rule for consideration by the commission?
Yes.
Okay. Did you prepare direct written testimony in preparation for this hearing?
Yes.
Is that marked as OCD exhibit number 6?
Yes.
And is that testimony true and correct to the best of your knowledge?
Yes.
Do you adopt that direct written testimony as your sworn testimony today?
Yes.
Okay. Did you also prepare your resume submitted as OCD exhibit number 7?
Yes.
And is that exhibit true and correct to the best of your knowledge?
Yes.
Okay. We've got a few more to go. Hang with me. Are you familiar with OCD exhibit number 16 marked as EPA UIC Program Class 6 Implementation Manual for UIC Program Directors?
Yes.
Okay. And you are generally familiar with that manual?
Yes.
And is OCD exhibit number 16 true and correct copy of that implementation manual to the best of your knowledge?
Yes.
Okay. Oh. I now have share capability, so I will transition to that. All right. All right. So going over so far, Dr. Schnaar, we have talked about OCD Exhibit 1, proposed changes to amended Exhibit 2A, OCD Exhibit 2, proposed changes to amended Exhibit 2B, OCD Exhibit 3, amended changes to OCD Exhibit, amended Exhibit 2C. You've referenced your direct testimony and your resume at Exhibit 7. We have also gotten through the UIC guidance for program directors at OCD Exhibit 7 to 16. I want to move on and ask you about OCD Exhibit 22. Dr. Schnaar, did you prepare pre-filed written rebuttal testimony in preparation for this hearing?
Yes.
Okay, and does Exhibit number 22, is that require any corrections today?
No.
And do you adopt your pre-filed written rebuttal testimony as your sworn rebuttal testimony this morning?
Yes.
Okay. Moving on to rebuttal exhibits. Dr. Schnaar, are you familiar with what I have on the screen here marked as OCD Exhibit number 26, Underground Injection Control Program Class 6 Well Site Characterization Guidance?
Yes.
And similar to the other guidance, is this a true and accurate copy of the reference guidance to the best of your knowledge?
Yes.
Okay. Similarly, for 27, Class 6 Well AOR Evaluation Corrective Action Guidance, are you familiar with this exhibit?
Yes.
And is it a true and accurate copy of the referenced guidance document?
Yes.
Okay. OCD Exhibit number 28, same questions. This is labeled as the Underground Injection Control Program Class 6 Well Testing and Monitoring Guidance. Are you familiar with this record?
Yes.
And is this a true and accurate copy?
Yes.
And lastly, OCD Exhibit number 29, EPA Key Principles and Class 6 Rule related to Class 2 transition. Are you familiar with this record?
Yes.
And do you, is this a true and accurate copy to the best of your knowledge?
Yes.
Okay. Madam Hearing Officer, I would move admission of OCD Exhibits 1, 2, 3, 6, 7, 16, 22, 26, 27, 28, and 29.
I'll pause for a moment in the event any other party would like to raise an objection. Those exhibits are admitted. Thank you.
Dr. Schnaar, did you prepare a demonstrative exhibit to facilitate a summary of your direct and rebuttal testimonies today?
Yes.
Okay. I am able to screen share that record. At this time, I would ask Dr. Schnaar to present the no longer than 1 hour summary of his direct testimony for the commission.
You move to the next slide. Next slide. Briefly, my professional background. I'm a hydrogeologist. I have a PhD in soil, water, and environmental science from the University of Arizona, and I am a certified professional geologist in several states. When it comes to carbon capture and storage, I'll refer to as CCS. I was a key member of the original federal Class 6 rulemaking as a postdoctoral fellow at US EPA. And then as a contractor with Daniel B. Stevens and Associates, or DBS&A, supported development of several of those technical guidance documents that we just went through. Since that time, I have worked with several project operators in different states throughout the country in applying for Class 6 permits and establishing monitoring programs under the Class 6 programs. In addition to that, my work for municipal agencies has included work for the U.S. Department of Justice. I have done some consulting work for the New Mexico Environment Department, California State Water Resources Control Board, and the California Department of Justice. Next slide. So the purpose of my testimony was really to explain the structure, both the framework and the technical structure of the Class 6 program proposed by the state of New Mexico. It really focuses quite a bit on what applicants need to submit in a Class 6 permit application that OCD will then review. And it covers the core requirements of the Class 6 program that I will get into. It shows how the New Mexico proposed rules reflect the federal Class 6 requirements. And it also addresses key New Mexico-specific provisions that add stringency as compared to the federal Class 6 rule. So briefly, I'll back up and just explain what the Class 6 program is. The purpose of the Class 6 UIC program is to regulate underground injection of CO2, specifically for the purposes of long-term geologic sequestration. And in doing so, protect underground sources of drinking water. And therefore, it sets minimum standards for siting, permitting, construction, operation, and well integrity or mechanical integrity. It covers monitoring, reporting, emergency response, what's called post-injection site care that I will get into, site closure, and the financial responsibility requirements. The overall aim is to ensure that the injected CO2 and the associated increased pressure effects in the subsurface do not endanger the environment. You can go to the next slide. But I want to back up and first talk about sort of the overall philosophy of how these risks are managed in the Class 6 program. And this diagram is meant to really explain that. This diagram is in most of those technical guidance documents that are exhibits. So the way this is intended to work is that an operator collects data on the geologic structure of where they intend to inject CO2. We call that site characterization. Quite a bit of requirements related to what kind of information they need to collect. They take that along with their proposed operating data. That is their injection volumes, injection rates, injection pressures, injection depths. They take all that information and they use a model to predict how CO2 will behave in the subsurface and how pressure will increase, map the extent of the CO2 plume, and that's this box that says computational modeling. That modeling is then used to delineate the area of review, which is the area where the operator has to search for other wells that could be conduits for fluid movement. But there's a recognition, we know that these models, especially at the outset, will have some uncertainty. So those models are also used in the next box, which is in designing a monitoring system to collect actual data on CO2 migration, pressure increases, and other aspects of the project. As we move into actually injecting CO2, that monitoring system is then used to collect data. The operators interpret that data. And then periodically, we move to the next box, which is model calibration on this slide. It's also a part of what is called area of review reevaluation. And in that process, we are essentially truing up our models to data that we have collected and reducing the uncertainty of those models. That new information is used to assess any areas that may have risk. And this entire circle of collecting data, updating the model is intended to be continue through the lifetime of the project. So you will see as part of this that model is a central framework of the original Class 6 application, and it's also used throughout the project to understand where there may be risks to the environment. When it comes to primacy, EPA can approve any state or tribe to run a UIC program in place of direct federal administration under the Safe Drinking Water Act. It requires that EPA review a primacy application and that the agency has the adequate legal authority, regulations, staffing, technical capabilities, and enforcement as least as stringent as the federal program. In New Mexico, OCD already has primacy for the Class 2 program. And NMED has primacy for several other well classes. So Class 6 primacy would extend that framework to the last remaining well class, and it would include OCD reviewing applications, issuing permits, and enforcing all requirements. And the benefit of the state of New Mexico having primacy would be a clearer permitting pathway for operators, but also a focus on locally informed review and oversight and additional opportunities for public review and participation in the rulemaking process. A key part of reviewing a proposed new injection well is making sure that there's no interference effects or cumulative impacts from multiple projects. And because the state of New Mexico already has primacy authority for all the other injection well classes, it's the most direct agency and entity to review potential new permit applications. So again, backing up a little bit to explain how this works over the lifetime of a Class 6 project. Again, this is a diagram from the Class 6 implementation manual. So first, the director, in this case OCD, would receive some notice of a project, and there's typically some pre-permitting coordination. And really the permit application review starts when the permit application is submitted. And we move to this red box, that's the pre-construction phase. And at that point, OCD would be reviewing the Class 6 permit application. If the determination is made to issue a permit, that is actually a permit to construct the Class 6 well. And it's recognized in the Class 6 program that during the drilling of that injection well, a lot of information and data will be collected that was not available during the initial permit application preparation. So for that reason, there is a second step where that data and information is used to assess the model and the adequacy of the initial application. And the OCD would then have to go through an authorization to inject before the operator could start injecting. So the initial Class 6 permit is a permit to construct, but the agency then has to give a subsequent approval for an authorization to inject before the project can actually start injecting. So then during the injection phase of a project, there is periodic reporting and oversight. And then the final step is after injection stops, the post-injection period does entail additional monitoring requirements. So even after you're done injecting, the Class 6 program would require some ongoing monitoring. And based on that monitoring data, the operator can then come to OCD for an application to close the site and end that ongoing monitoring. And that would be the final step, would be authorization of site closure. So what is an actual Class 6 permit application? I've worked on several of these. They're typically several hundred pages long and include multiple sections. The left-hand column here is just a summary of the different plans and application components. So briefly, the main document is what's called the narrative, includes all of the site characterization data, all of the well construction information. The next is the area of review and corrective action, which really focuses on the modeling used to define this area of review, and any search for wells within that area of review that may require what's called corrective action, or actions to remediate those wells so they are not conduits for fluid movement. The testing and monitoring plan is the third. That is the plan the operator has to monitor all different aspects of the project. The injection well plugging plan would be there, so at the end of injection, the injection well is plugged in a manner to protect the environment. Post-injection site care refers to this period after injection ends when monitoring continues, and so there's a separate plan where the operator lays out how they will monitor the site. The emergency remedial response plan outlines how the operator will respond to any emergencies if they arise. The operator is required to demonstrate that they have financial responsibility, as I'll talk about. The pre-operational testing plan is the plan to collect that information after they receive the permit to construct and during the construction of the injection well. And it outlines what data will be collected and how that data will be presented to OCD. And the final is there may be a requirement to outline compliance with certain federal laws. This can include a biological assessment. Again, relying on a diagram modified from EPA guidance. This is just another outline of the permit review framework from the initial submission. So the permit application is submitted to OCD in this case. And the first stage in that is what's called a completeness review. So as I outlined, these are heavily technically dense documents with a lot of requirements. There are various checklists that the different agencies have put out to make sure that you have every single piece of information that's required. I don't think I've ever worked on one of these where there wasn't something that the agency then said was missing. And so in that completeness review, they flag some piece of data or information that they expect to be in the application. And then they go back to the applicant to submit that missing information. Once that is resolved, the OCD would start the technical review of the entire application, all those different components. And at that stage could either make a determination to reject a Class 6 permit application or move to prepare a draft permit, at which point there is a public comment period and a final permit decision. Next slide. So I'll move into what I call the key components of this Class 6 program and highlight how these work. And again, I'll talk at the end how New Mexico has layered increased stringency on this, but much of this is similar or the same in the federal and proposed New Mexico programs. So the first is site characterization. And the main things that the applicant has to demonstrate are that they have a injection zone that can receive the proposed fluid, has adequate size, permeability, porosity to receive the proposed injected CO2, and that is a confining layer or confining zone above that injection layer that will restrict upwards movement. Those are really the two key factors. Also would need to demonstrate that that confining zone is free of any transmissive fractures or faults that would lead to leakage through that confining layer. And lastly, it's very important to outline the distance between the injection interval and the lowest underground source of drinking water, or USDW. So typically, quite a bit of information is given on the salinity and depth of all the different aquifer zones above the injection zone. Next slide. Next, getting to area of review. As I've explained, the area of review is the area around the project where operators must search for other wells that may be present or other features that could lead to leakage of carbon dioxide. And it is required to be delineated with very complex computational models. And the proposed New Mexico rule, as I said, requires periodic reevaluation of that area of review, which is the step of truing up your model with any data that you have collected in the intervening time period. And if that AOR reevaluation process leads to a different area of review, they must at that point update any corrective action plans for wells that are in that new area. Next slide. So this is an example for one of the EPA guidance documents. The area of review is really required to be the outermost area of two separate things. The first being the area of the free phase CO2 plume. So we're injecting CO2 under pressures that it will be supercritical in the subsurface. And that CO2 plume is one feature that has to be considered. The other is what is referred to sometimes as the pressure front. It's the area of increased pressure such that pressures are so high that they may, if there was a leakage pathway there, endanger USDWs. So in this diagram, the blue, this is just a hypothetical example. There's 3 injection wells. The blue is the outermost extent of the CO2 plume. The orange is that pressure front area. And the purple dashed line is the final area of review, just demonstrating that it's the outermost extent of both those potential features. Next slide. So So the corrective action, as I've outlined, entails identifying and reviewing wells within that area. These may be former production wells, injection wells, or any other transmission features that are there, really to ensure that they are adequately plugged so that they won't themselves become a pathway for CO2 to leak upwards. Next slide. The next key component is the injection well construction requirements themselves. So the Class 6 program recognizes that the area of greatest risk is typically at the injection well itself, because the injection well is where pressures are greatest. And so there are stringent requirements for Class 6 well construction materials to be compatible with the underground formations and the injected CO2, so that over the lifetime of the project, CO2 doesn't leak up that well. So those requirements are there to ensure that the injection well maintains integrity over the life of the project. Next. This is a diagram, again, from the guidance documents, and it really is an overview of an important component, which is the testing and monitoring program. So the top part of this is a graph. You'll see this blue line, and it's just an example, but it's meant to outline when there are risks associated with these projects. So during the siting and evaluation stage, there's very little risk. During the actual well construction, there is some risk of leakage, so that blue line increases. And then as CO2 injection begins, that risk is recognized to increase over time, and that's because pressures in the subsurface will increase over time, up to some level. And then after injection ends, those risks don't just disappear. That's why there is this post-injection site care period. So as the blue graph shows here, as you move into the post-injection site care period, those risks do decline, but it's not instantaneous, and it takes some time. And it's not until those risks are essentially back to their beginning state that the project would be issued closure and that monitoring would end. So all of these additional rows underneath this graph are the monitoring and testing aspects of Class 6 projects that are intended to assess and manage these associated risks. And you can see they are kind of tailored to the different timeframes. So for example, mechanical integrity testing begins at the end of well construction. And because this is mechanical integrity testing of the injection well, it would then end at the end of injection. So this is testing of the actual injection well to maintain to make sure that it maintains mechanical integrity. The next is analysis of the carbon dioxide stream. So in the initial permit application, the applicant they propose what will be in their injected stream. It will not be 100% CO2 in most cases. It may contain water vapor, H2S, other things that have different risk profiles. So to ensure that they are in compliance with the permit, they actually are required to monitor that stream as it's being injected during that time frame. Monitoring injection pressure, rate, and volume, again, to maintain compliance with the rule during the injection phase, as well as corrosion monitoring. So corrosion monitoring is required to ensure that the injection well is not corroding, and that, again, is during the injection phase of the project. Monitoring for groundwater quality above the confining zone to detect any potential leakage or risks. Typically starts before injection begins to have some baseline, and then is required through the end of the post-injection site care period. Pressure fall-off testing to assess the near wellbore area and the subsurface of the injection zone during the injection phase. And then lastly, a very important component is actually monitoring to track the lateral extent of the plume and this area of elevated pressure to make sure that it's conforming to what the original modeling said. And again, that would occur primarily during the injection and then post-injection timeframes. So that's really an overview of all of the testing and monitoring. Next slide. Briefly, and then I'll move on for time. This is an example from the Class 6 guidance documents of one of the different geophysical techniques that's in place to actually track the CO2 plume. And this is actually shown in cross-section for an actual project in the North Sea and how that CO2 has migrated over time from 1994 to 2006. Next slide. All right, one area where New Mexico has added increased stringency compared to the federal rule is in requiring seismicity monitoring. So that refers to monitoring for the occurrence of any type of earth movement or earthquake that may be related to the increased pressures in the subsurface from the injection project. And New Mexico is going to require seismicity monitoring during the operation and post-injection for all Class 6 projects. If seismicity is detected, the emergency and remedial response plan would outline what steps need to be taken. And that may include reducing injection rates or pressures, suspending injection, increased monitoring, updating the models, revising the permit limits, et cetera. Next slide. The reporting requirements, another component of the rule. So during the life of the project, the operators will be required to submit reports on the Class 6 operations, things that will include all of the monitoring data, like the CO2 stream characteristics I spoke of, injection rates and pressures. And those reports will let OCD compare the actual performance against the permit assumptions. Non-compliance reporting covers conditions that may endanger health or the environment, USDW endangerment, fluid migration, any triggering of shutoff devices, and information indicating endangerment must be reported within required timeframes, including a 24-hour reporting for urgent conditions. All right, moving through the different phases of these projects, post-injection site care, often referred to as PISC, again, is this period after injection ends. And it's important because monitoring is performed during that time period. And the default time frame for post-injection site care in the rules is 50 years after injection ends. But operators can petition during their initial permit application to have a shorter post-injection site care time frame. So for example, if you have a project that's only injecting for 5 years, they may be able to show that pressures will decline fairly quickly, the CO2 plume will not be migrating, and they may make an application with several required components to the OCD to have a shorter post-injection time frame default during their project than the initial required 50 years. But no matter what their PISC time frame is, at that time, when they are actually done injecting and they've been collecting data, they don't just stop at 50 years or 5 years if they have an alternative time frame. They actually have to submit a non-endangerment demonstration to the OCD at that stage to show that the project risk profile has lowered and they can receive a permit. Next slide. The operators are required to demonstrate and maintain financial responsibility enough to cover corrective action, injection well plugging, post-injection site care enclosure, and emergency and remedial response. They have to show that they have adequate resources are available to perform any required Class 6 obligations if the operator was unable or unwilling to do so. The operator then has to establish a funding mechanism before injection and maintain it while obligations remain, reducing the risk of any delayed or unfunded protective work. And this supports New Mexico's primacy request with enforceable mechanisms ensuring funds are available to protect USDWs across the project lifecycle. Next slide. So another issue that is addressed in both the federal and the New Mexico rules is that there is inherent potential overlap between the Class 2 program and the Class 6 program. And that is because, as outlined in this schematic from EPA, Class 2 wells may inject CO2 for enhanced oil recovery or other reasons. And there may be an instance where an operator is already injecting CO2 for enhanced oil recovery, and then also begins to inject CO2 for other reasons to permanently sequester the CO2. And so the rule addresses that overlap. You can go to the next slide. In having a certain requirements that the OCD director is required to evaluate in determining if a well really should be class 6 instead of class 2. So to hammer this home, a class 2 well can't just all of a sudden automatically start operating as a class 6 without authorization. The operator would have to actually apply for a class 6 permit. And then OCD would review that class 6 under the standards before authorizing it. But again, there may be this time period when the class 2 well is injecting CO2 for multiple purposes, and that is when the OCD director under the rule will be required to evaluate the project under these bulleted lists to see if a class 6 permit really should be required instead of a class 2. And that would be if there's an increase in reservoir pressure within the injection zones compared to the previous operation of the project, an increase in carbon dioxide injection rates, a decrease in reservoir production rates. Looking at risks that can be characterized as the distance between the injection zone and the lowermost USDW, the suitability of the existing class 2 area of review delineation, the quality of any abandoned well plugs within the area of review, really assessing the owner or operator's plan for recovery of carbon dioxide at the end of their injection, the source and properties of the injected CO2, and any other factors that they deem appropriate. So again, these are all the factors that the OCD would then evaluate in determining if a class 2 project should be required to come in for a class 6 permit application.
Dr. Schnaar, I have us at approximately half of your time.
Great. Okay, thank you. Another feature of the rule is what's called an injection depth waiver. So in the vast majority of cases, these injection projects will occur below the lowermost underground source of drinking water, but there may be some limited circumstances where they are actually injecting between the lowermost one USDW and another one. And if they propose to do that, they have to come in with another part of their permit application, in addition to that whole list I presented before, that's called an injection depth waiver. And essentially, it's another batch of site characterization data, a lot of information on that most lower USDW to ensure that there won't be risks to any USDWs above or below the project. They are required to plan for monitoring both USDWs. So again, just another requirement for OCD to evaluate before they would be able to approve a project if it was not below the lowermost USDW. In all cases, they cannot inject into a USDW, but this would be instances where they're injecting between USDWs. All right, so I want to take some time to focus on this. This last aspect are the areas where the New Mexico rule is more stringent than the federal rule. So as was discussed previously, in a primacy application, the operator, the state in this instance is required to show that their rule is at least as stringent as the federal rule, but it may be more stringent. And these are areas where the proposed New Mexico regulation are more stringent than the federal rule. All right, so first, community outreach. So the proposed rule, the initial permit application must contain a summary of community outreach activities. There's no requirement for that in the federal rule. And community engagement is required to be performed during development of the testing and monitoring plan. So what that means in practice is the operator would be required to coordinate with community groups in the area in the area of review to actually develop a testing and monitoring plan in coordination with that community. And then lastly, the owner or operator of the project must conduct outreach within with communities located within the area of review, also during the development of the emergency and remedial response plan. So that would include coordination with local emergency responders. And again, that's something that's just not required in the federal rule. That's added here under the state framework. Another area of increased stringency in the New Mexico rule is in the testing and monitoring. So first, the federal rule just requires periodic groundwater monitoring above the confining zone. So above the confining zone, and typically below the lowermost USDW, projects are required to monitor groundwater quality for any indication of potential CO2 leakage. The federal requirement leaves that open-ended as to what periodic means, but the state of New Mexico rule as proposed would require quarterly groundwater monitoring. So the second would be soil gas monitoring. So the federal rule does not require any monitoring of shallow soil gas. This is a photo of my colleague. I took this picture performing soil gas monitoring at a CCS project. And the state rule would actually require this soil gas monitoring and periodic reporting. And again, this would be just another indication of potential leakage. So you'd be monitoring for CO2, other gases in the subsurface, comparing that to either a baseline or areas outside of the project area to see if there's an increase in CO2 that may indicate a potential leakage around the project. Again, as I mentioned, seismicity monitoring is required. I covered that. And then lastly, the federal rule requires a reevaluation of the area of review. The state of New Mexico has added a layer to that there must be periodic reevaluation of the testing and monitoring plan itself to see if any additional monitoring or changes to the monitoring plan are necessary. Next slide. Areas of increased stringency related to well construction. First is that the state would say that the permit is only valid for 2 years from the date of issuance, whereas the federal rule leaves that open-ended. The state rule also requires cement type or grade, slurry density, and volumetric yield be submitted with the injection well construction evaluation. It would require another type of well log, gamma ray logs, that are not required under the federal rule. And it also requires that all alarms be integrated with automated shutdown systems and that those shutdown systems be tested once every 6 months. Next slide. All right, another area of increased stringency, coming back to this diagram I started with. This really comes down to how quickly and how often you have to kind of move through this circle of truing up your actual data with your model, this AOR reevaluation. The federal framework says that you have to perform this AOR reevaluation at least once every 5 years, or if there are specific triggers that are outlined in your initial permit. Like, for example, if your pressures are outside of a certain tolerance, that might be a reason you have to do it more than once every 5 years. So the state of New Mexico rule has added stringency to that by saying it's not once every 5 years, it's actually 2 years after the injection starts, and then no less frequently than every 4 years thereafter. And the reason for that initial 2 years is that is seen as sort of the first practical time period where there's enough data that you've collected from your injection project itself to really critically evaluate the model and have time to run the model and evaluate that data. So that's why there's an initial 2 years, again, much shorter than the 5 years that would be required under the federal rules. And then again, no less frequently than every 4 years thereafter. Next slide. When it comes to injection well plugging, the areas of increased stringency compared to the federal rule, the injection well plugging plan must include a detailed description of the size and quantity of the casing, tubing, and any other well construction materials proposed for removal prior to well closure, and pre-closure and post-closure well schematics. The well plugging report, when you're actually plugging the well, must also include a detailed description of site closure procedures, clearly identifying any deviations from the submitted plan during the closure process. All right, so that kind of was an overview of the key areas of increased stringency. I think the last thing I would mention here relates to what was already discussed with these rule language changes. So my understanding is that this really was driven by requirements from the New Mexico State Record Center and Archives, and it was non-substantive changes to remove, for example, the section symbol with the word section. There was an issue where the federal rule uses and/or, and so in most places that was replaced with language that is equivalent, saying, for example, instead of X and or Y, it would say X, comma, Y, comma, or both. So really the intent is the same. There was a limited number of instances where just due to the specific language in the phrase, it made more sense to use an or an and rather than or both. And that OCD determined that this language satisfied the substantive requirements and intent of the federal Class 6 regulations and does not otherwise render the proposed rule less stringent than the corresponding federal Class 6 requirements.
Dr. Schnaar, is there anything else that you would like to add at this point to wrap up the summary of your direct testimony?
No.
Thank you. Madam Hearing Officer, I would move on to rebuttal at this point. Dr. Schnaar, we've already clarified what this is. I have the slide up. I would now ask that you provide a summary of your pre-filed written rebuttal testimony for the Commission.
Sounds good. Next slide. So my understanding is, we reviewed red lines and reports recommending changes to the state rule. And these came from the Center for Biological Diversity, what's called the conservation groups here, and OCC USA or OCC. And I evaluated each of those red lines and the underlying explanation for those. And this slide summarizes where I disagreed or agreed with those proposed changes. For the most part, we would have disagreed with something if there was a potential issue with stringency compared to the federal program. Or in many cases, there was proposed much more specific, detailed language that, in my opinion, is better left to guidance and to project-specific permit reviews than to actual regulatory text. So you can see there were some instances where I agreed with the changes. So this really summarizes the main points that I responded to for each of the proposed red lines from each of the parties. And in the subsequent slides, I'll get into detail on many of these. Next slide. So the first is the area of review definition. The conservation groups proposed a change to the definition of the area of review, removing reference to area permits. That language really was there as a carryover from the federal rule and was never intended and didn't really refer to Class 6 area permits, which are prohibited. So an area permit would be actually approving multiple injection wells under one permit, and that's just prohibited under the Class 6 program. So I agree with this change to clarify the area of review definition in the proposed text. So if you look at the three exhibits, there's actually 3 times there's an area of review definition. And what I would propose, as opposed to the red line that's shown here, is just to adopt the area of review definition from the final the definition at 1915-43-9B1, which is what I've copied here, and just use that throughout. And I believe that would address the comment and is more specific to Class 6 and how our area of review is under Class 6. So I agree with the intent of the change, but my fix would be a little different. I would just repeat the area of review definition that was not edited by the conservation groups. That would be my recommendation. All right, the Center for Biological Diversity proposed to change, really establishing a minimum area for siting and site characterization, proposing a 10-mile radius for site characterization, and then in some instances requiring corrective action within that 10-mile area minimum. I didn't agree with this change. The intent of the class program is really to build site-specific and project-specific area review based on specifics of the project. So for example, a well that's proposed to inject only for 2 or 3 years would have a very different risk profile and area of potential impacts than a project injecting for 50 years. So the reason for this initial site characterization modeling process is to find where this project is actually going to have impacts. And so I don't agree with the proposal to just have a blanket 10-mile minimum radius of site characterization. So I did not agree with this change. CBD also proposed specific criteria for a mandatory reevaluation of the area of review. So like I said, the operators are required to reevaluate the area of review at some minimum time frame, but there also are specific triggers that would cause them to have to do it sooner. And the way that the Class 6 regulations are written and proposed is that those triggers would be project specific and written into the initial area of review and corrective action plan. So OCD would have input and oversight on those triggers, but they would be project specific. So again, I don't agree with actually listing specific triggers in the regulatory text. I think that's better left to be project specific, and there is a stage for OCD oversight during the permit application review stage. So I would defer to that. Another thing I would say is, as included as several exhibits here, the Class 6 guidance documents, OCD intends to rely on those Class 6 guidance documents from the federal EPA, and considerations in development of those triggers and many of the more specific aspects of these projects are covered in detail in those guidance documents, and that's where I think it's appropriately addressed. OCD proposed to remove the requirement for AOR reevaluation 2 years after injection begins and no longer than every 4 years, and replace that with the federal minimum requirement of once every 5 years. And I did not agree with that. In drafting the state rules, New Mexico deliberately adopted a more frequent area of review reevaluation schedule than the federal minimum to ensure that these predictive models are periodically compared against actual monitoring and operational data. And as I said, that 2 years was seen as the first practical time that projects would have data to really perform this process. And so it was seen as a way of more quickly moving through this process of truing up the data and the model, which is a key aspect of how the Class 6 program manages risk. So that's why I don't agree with of going back to the default EPA every 5 years. The conservation groups, again, related to the area of review. As I've said, this model is a very central part of their initial permit application, and the conservation groups propose specific regulatory text requiring that an independent third party verify the modeling. And you can go to the next slide. This is just the red lines. Again, I don't agree with that. I do believe that OCD themselves and any contracting support they deem they require is the most effective party to review this modeling. OCD is responsible and its technical staff to review these permit applications, including all the modeling inputs and assumptions and methodologies submitted by applicants. Evaluating the adequacy of that technical analysis is a core regulatory function. OCD will have the expertise to do that, and where needed, specialized expertise can be brought in by retaining consulting independent technical experts to assist in evaluating those complex modeling issues. So I believe that that is the most appropriate place for the modeling to be reviewed, is with OCD and its own resources. Requiring third-party verification for all projects would add significant cost and administrative burden without a corresponding increase in protection of USDWs. I've actually been through this process, and based on my experience, the third-party review and verification adds significant time and very little benefit, and I would, again, I would keep that review capacity with the OCD. Okay, the conservation groups, I went through this list earlier. I was talking about what the OCD director would be required to review when it comes to whether or not a class 2 well really needs to come in for a class 6 permit. And I actually read through this list. And the conservation groups proposed a change to transitioning from class 2 to class 6, adding another criteria to this list, which was the integrity of the caprock seal for long-term containment. So long-term containment, a different objective as compared to the initial EOR project or CO2 injection project under class 2. So I agree with this change. I think it makes sense that an additional criteria would be added. So this is, I agree with adding this as a criteria. The only, I guess, language quibble I would have with this is that instead of saying integrity of the caprock seal, I would say integrity of the confining layer or the confining zone, just because that's the language and definition that's used in the class 6 rule, as opposed to caprock seal, but it's the same idea. And again, I agree with the intent of this change. I explained that the state rule has already added stringency in requiring soil gas monitoring, not required in the federal program. CBD would expand that requirement, that a mandatory 1 year of background soil gas monitoring be required, and it would include a type of soil gas monitoring for isotopes, isotopic monitoring. I don't agree with those specific provisions. Again, as someone who's actually been out there doing this, I don't agree that in all cases a full year of baseline data would be required, and I think that's better left to a project-specific determination. The usefulness of baseline data is that when you see CO2 concentrations fluctuating during the life of your project, you have something you can compare against. But the operators would also have the opportunity to rely on CO2 monitoring outside of the area of their project instead of only data that was collected before their project started. And there may not be a need really for a full year of that baseline monitoring. So I don't agree with that. Isotopic monitoring is very specialized. It require specialized equipment. For example, what is shown in this photo is a soil flux chamber, which is a really useful tool because of the flexibility of monitoring CO2 in soil at many different locations as opposed to a fixed well. You also get immediate real-time results. Requiring isotopic monitoring would preclude the use of these standard flux chambers, for example, really requiring specialized equipment, and I don't think it would be useful in all cases. The operators would also have the opportunity to do isotopic monitoring. The reason for requiring any kind of isotopic monitoring, I assume, is that it would be helpful to distinguish between the CO2 that's just natively in the subsurface versus something that's leaking from down below. Those two types of CO2 may have different isotopic signatures. So it's a way of determining where the CO2 may be coming from if you're seeing it in soil gas. But my point would be that there are other ways of doing that. You can look at soil gas ratios, for example, CO2 to methane. And so I wouldn't want to hamstring the operators and OCD in their review by requiring a very specific thing with isotopic monitoring. I would leave that to a project-specific determination. Surface air monitoring. In both the federal and the state rule, actual monitoring of CO2 in the air above a project is left to the discretion of the director. So it's not required, but it is listed as something that may be required on a project-specific basis. Again, this is a photo I took of actually setting up an air monitoring station at a CCS project. And I would not change the rules written. I would not require surface air monitoring in all cases. I don't believe that it's required for all projects. I think the groundwater monitoring above the confining zone and different intervals in the subsurface and the soil gas monitoring is sufficient to track potential CO2 leakage. And I don't think that surface air monitoring would be useful in all cases, and I wouldn't require it for all projects in New Mexico. So I don't agree with this change. All right, moving on to monitoring well construction standards. So these are really what the conservation groups for. I'll back up. The rules as written have, as I spoke about, pretty specific requirements that the injection well construction itself is sufficient to preclude migration of CO2 upwards. The conservation groups would add monitoring wells to those requirements. And I agree with that intent of that it makes sense to actually list monitoring wells and ensure that they themselves also aren't a pathway for fluid movement. And of most concern would be monitoring wells that actually penetrate through the confining layer all the way to the injection zone. So to back up, operators are required to monitor the projects. They are required to monitor pressure in the injection zone. That will require monitoring wells in the injection zone. So these projects themselves will be using wells and in most cases installing monitoring wells that themselves could be a leakage pathway if they are not constructed correctly. So I agree with requiring certain, that those monitoring wells be constructed in a way that they won't lead to fluid migration out of the injection zone. The reason I agree in part is because the conservation groups kind of just use a blanket term for all monitoring wells. I would really only add these requirements for those injection wells that penetrate the confining layer. There are many different types of monitoring wells. There may be very shallow monitoring wells in USDWs that are only a couple hundred feet deep. So I would not require specific construction standards for all monitoring wells, but I would think it's reasonable to have include that monitoring wells that penetrate the confining layer have certain requirements. So what I've done is in my response, in my rebuttal, I proposed my own red lines that I think, again, I understand the intent and I agree with it, but really focus more on those deeper monitoring wells to distinguish and not layer requirements that don't make any sense on very shallow monitoring wells. The conservation groups also proposed to add a minimum of 4 monitoring wells, and they also had language that would require monitoring well placement based on very specific modeling scenarios. I don't agree with those changes. Again, I look at this as very project specific. The number of monitoring wells you would think would be much lower for projects that are operating at smaller injection volumes, less time period. It really makes more sense that be a project-specific determination. Considerations for monitoring well placement are covered in the EPA technical guidance documents that OCD will be using. And it will also be something that's a really key part of the testing and monitoring plan that OCD will review. So I think that the number and placement of monitoring wells is really project-specific and is better covered in project-specific oversight during the permit application stage. So I wouldn't recommend and don't agree with the red lines that are shown here. OCC proposed removing the increased stringency of quarterly groundwater quality monitoring and reverting back to the federal language of periodic, so leaving that frequency unspecified. I don't agree with that. This was an area where the state determined, or OCD determined in the proposed rules to add increased stringency and intentionally selected quarterly groundwater monitoring to ensure that groundwater quality and geochemical data are collected frequently enough to identify potential migration. It provides a consistent data set for evaluating trends, validating model predictions, and supporting timely regulatory response if there were to be anomalous readings. And I also say that in my experience, it is also the standard and the norm at CCS projects throughout the country. So although the federal requirement is periodic, in practice, projects I've worked on have really, for the most part, agreed to a quarterly monitoring. So it's not adding a ton compared to other projects throughout the country. Next slide. All right, so the conservation groups, I did kind of gloss over this, but there is a requirement for what's called plume and pressure front tracking. And this is monitoring to track the extent of the plume in the area of elevated pressure. The conservation groups proposed some red lines that would require continuous monitoring to track the extent of the carbon dioxide plume. And in using that word continuous, this would be essentially some type of monitoring technology that's collecting data routinely throughout every single day. And when it comes to plume tracking, I don't believe that's practical. There are requirements for continuous pressure monitoring, for example. These are gauges that are always collecting pressure data. But when it comes to plume tracking, that would preclude most, if not all, plume tracking technologies I'm aware of. And so I wouldn't agree that's a practical change, that there would be continuous plume tracking. And that's really something that is done on a more periodic basis than continuous. So I don't agree with that change. I spoke about the alternative post-injection site care timeframe. Again, the default is 50 years, but during the initial permit application, operators can make a demonstration for review and potential approval that timeframe should be shorter, their assumed default timeframe. And the conservation groups, they proposed language that would remove that ability to have a shorter default time period than 50 years. Again, I don't agree with that. The intent of this is, again, that there may be some projects that have a much lower risk profile and maybe taking active steps during the entire operation of the project to reduce their risks. And they may, for that reason, there should be the opportunity to have a shorter default post-injection site care timeframe. And again, this is something that would be reviewed by OCD. In my experience, this is something that gets a lot of review in permit applications. In many cases, they may not agree to it. There may be some middle ground between what's applied for and 50 years. And it really should be a project-specific determination. And in reality, really, operators will be required to continue monitoring no matter what, until OCD agrees to their non-endangerment demonstration. So I would retain what's included in the federal rule to allow for an alternative post-injection site care time frame, and I don't agree with the red line change. All right, I think this may be last. OCD proposed a catch-all category to minor modifications of permits. So I didn't really speak to major versus minor permit modifications, but the federal rule and the proposed state rule do have a list of what would be considered a minor permit modification. And OCD proposed to add to that a catch-all category, saying that minor modifications would include non-material, non-substantive permit modifications that do not increase risk to USDWs. I think the next slide. I don't agree with that proposed language. If you look at the list that was above it, there was already quite a bit of discussion of what would consider to be minor. For example, it says changes to all of these plans that are just clarifying and don't change the plans in a more significant way. I think the terms that were suggested of non-material and non-substantive could be confusing. They could be looked at as subjective. I don't really think they add a lot to what would be made in this determination. So I don't agree with that red line. And I believe that the current rule already provides the director with adequate discretion while maintaining clear boundaries around the types of changes that may be processed as a minor mod to the permit.
That wraps up Dr. Schnaar's summary of his rebuttal testimony. I'll just ask the doctor if there's anything else we haven't covered that you feel is appropriate to bring to the commission's attention in terms of your rebuttal.
No.
Okay. So at this point, I would move on to my next witness, and we'll keep Dr. Schnaar in the room and under oath for later panel.
Thank you.
Madam Hearing Officer, with it being 11:35, I believe that Mr. Wrinkle will be shorter, so I would call him now. It's possible we may go into.
We have a request to take an early lunch, Mr. Tremaine.
That's all right. Mr. Wrinkle will back after.
All right. Is an hour enough or hour 10?
Hour 10.
All right. So let's come back at 12:45. Thanks so much.